Good afternoon, everyone. My name is Maya Luria with TMC for Seniors, and we are now in the month of April, and it is Healthcare Decisions Month. So we want to make sure that you have all the information that you need, and we're going to start off today with empowering decisions, wills and powers of attorney. I have Shanelle Schmitz here with me. She is with the law office of David Karp. Shanelle, you have done so many presentations for us, and we appreciate that. You specialize in elder law, so thank you so much for being here today to talk about, wills and powers of attorney.
Yeah, of course. Happy to be here, and thank you everyone for attending. So as Maya was saying, I work for the law office of David Karp. I'm an attorney who focuses my practice on estate planning, probate and trust administration, and some guardianship and conservatorship cases. I've been practicing in this area for quite some time now, and I enjoy giving these presentations. So today we're going to be talking about empowering decisions, wills, and powers of attorney. So let me go ahead and, so here's my contact information, and I have some cards on the table for those who are attending in person as well. That way you know how to reach me if you have questions after this presentation. And I'm an attorney, so of course I'm going to have a legal disclaimer. So essentially, anything that's presented today is not formal legal advice. It's very important for everyone to talk to an attorney about their own estate plan. Estate planning is very personal. So what I go over is broad information, but it's important to have a specific plan for each of your individual needs. Okay, so I'm going to get started by going over what is a will and some common questions about wills that I run into on a regular basis. So a will is effective only upon death. So it's not effective while you're alive, and it requires probate court to be effective. A lot of people don't fully understand that a will has to be probated in order to give any kind of legal authority to who you name in the will as your personal representative, and then to basically administer your estate. So as you'll see on the slide, so within your will, you should name your personal representative, otherwise known as executor. So in every other state except for Arizona, it's called executor. Arizona just had to be different or difficult, whichever way you want to think about it. So personal representative is who is administering your estate after you pass. So who would have the legal authority to basically take control of your assets and then distribute them. So within the will, it designates where your property goes as well. It also directs the payment of debts and taxes. But again, a common misconception is that it requires probate court to be effective. So I like to describe a will as instructions to the court as to how you want your assets to be distributed. Within a will, there's a lot that you can do that not everyone realizes. So you can name a guardian for your minor children. So if you have any children that are under the age of 18, you'll want to name a guardian. That way, if something happens to you, this is who would be in charge of making medical and placement decisions for that child. You can also name a guardian for an incapacitated unmarried adult. So if you have a child who has disabilities and doesn't have the capacity to make their own decisions, then as a parent, you can name someone who can make those decisions for them after you pass. So it's important to think about that if you're in that situation. That way you have a voice as to who can make those decisions for that child. You can also name a guardian for an incapacitated spouse. So let's say your spouse has Alzheimer's or dementia, and they're not able to take care of themselves. They're not able to make their own decisions. Within your will, you can specify who you want to serve in the role of guardian if something happens to you. So one common question related to wills that I get is whether or not you can avoid probate with the will-based plan. Does anyone have any guesses? No. Okay, so for online, guess is no. Actually, you can avoid probate with the will-based plan if you set things up specifically. And we're going to hold all questions until the end, but there will be a time for questions.
Define probate.
So probate is the court process. So essentially, think of it as probate court. So it's the process that you have to go through the court. So there's court involvement. There's documents that have to be filed with the court. Sometimes there's hearings involved, not always. So we'll kind of go over that a little bit more thoroughly, but think of it as court. Okay, so how do you avoid probate with the will-based plan? So essentially, you're wanting to look at how do you transfer your assets directly to beneficiaries upon your death. And this is all in the event that you don't have a trust set up. A trust is very different than what we're talking about right now. So there's different ways to directly have your assets go to beneficiaries. One would be by operation of law, so joint tenancy with rights of survivorship or community property with rights of survivorship. So a lot of times you'll see on your, if you own property with your spouse, you'll want to look at the deed to the real property and see what it says. A lot of times you'll see community property with rights of survivorship. What that means is that if something happens to you, 100% of the interest goes to the surviving spouse, vice versa. You can have that set up with the joint tenancy with right of survivorship, with other family members, friends as well. If you don't have the with rights of survivorship language, then it doesn't automatically transfer to those people. You can also have beneficiary designations. So on any kind of bank account, you can actually have them on vehicles as well. So Arizona Motor Vehicle Department has a form that you can actually get online. It doesn't even have to be notarized. And you can specify where your vehicle goes if something happens to you. Pay on death or transfer on death designations. So that's just different terminology for beneficiary designations. So essentially that's what usually financial institutions, so if you have investment accounts, IRAs, anything like that, you can set up pay on death or transfer on death designations, and then a beneficiary deed for real property. So beneficiary deeds for real property are helpful if you don't want someone to be a joint owner. And that's really important. A lot of times people will think it's best to have a joint owner on the property to make it easier for them to receive it upon their death. And that's not always the case. And there's different negative implications that can happen with that. So a beneficiary deed is in place. So say I own a piece of property and I want it to go directly to my daughter upon my death. I can have a beneficiary deed on that real property and then it transfers directly to her upon my death. Now, there's never a 100% guarantee that you can avoid the court process, the probate court process. So for instance, if you were in an accident, so say a drunk driver hit you and they killed you. Now your family has a claim against that drunk driver and their insurance company. So they would have to go through the probate court and get someone appointed to be able to have the legal authority to deal with the settlement and collect those assets. So it's never a 100% guarantee to avoid probate with the will-based plan, but there are ways to do so if you have your entire estate plan set up correctly. So another common question related to wills. So is it always best to try to avoid probate, the probate court process? And I'm going to give you a lawyer answer. It depends. So a lot of times clients are terrified of probate. They want to make sure that they never have their estate go through probate. They hear on the radio ads that, they can take half your estate in probate court. The fees are outrageous. So it's not always the case. In Arizona is set up very differently than some other states. Arizona, it's not that difficult of a process for probate court. Now in California, if you own real property in California, you really want to talk to an attorney about setting up a trust. In California, they have a statutory requirement for how much attorney fees are paid from the estate. So as I was preparing for the presentation, I wanted to see what would an attorney get paid for administering a probate in California for $1 million. Does anyone have any guesses what those fees might look like?
$100,000.
Not quite that high, luckily, but $23,000. So that's a lot. And that means that's less money going to your beneficiaries. So in Arizona, it's usually a lot less. So some firms in town will charge a percentage of the estate. We don't do that. We charge based on the work that we complete. So we would usually charge a flat fee to open the probate and then hourly after that. So the client's more in control over how much we assist with. And I'd say our average no fight probate is around 5,000 to 6,000, sometimes less, sometimes more, but it's a lot less than the 23,000. So sometimes it does make sense to have a probate-based plan. So one of the points I have on here is if you have a beneficiary deed to multiple beneficiaries. So sometimes a client will come to me and their only asset really is a house. So they don't have other reasons that they need a trust set up. So then we're looking at, okay, so we need to transfer this house, and say they have 5 children. So upon your death, we need to transfer it equally. They want it equally among the 5 children. It doesn't always make sense to have the beneficiary deed, because then all 5 children will get a 5th interest in the house. So if all 5 children don't agree on what happens to the house, then it creates problems, and you end up in court battles, because they have to force. So if one child wants to force the sale of the property, they'll have to petition the court to force it if the children don't agree. So one way that that's dealt with is by having a probate-based plan. So upon your death, it goes through the probate court process. One person is in charge, appointed as a personal representative of the estate. Now it's one person in charge of selling the property and distributing the proceeds amongst the 5 people. So that might be a situation where you actually may want it to go through probate court. Charities, so sometimes if someone has a house and all the contents and they're leaving it to a charity, the charity would probably rather have the liquid assets. So they would have it go through probate, have someone else basically sell the real property, take care of selling the tangible personal property, and then distribute the proceeds to the charity. So those are situations where it might make sense to actually have a probate-based plan. And then another common question I get. So a lot of people have trust set up, and I'll touch a little bit on trust on this presentation. But if you have a trust-based plan, do you also need a will? And there's a lot of confusion on this. I've even had attorneys confused on this before. What do you all think? Do you think you need a will if you have a trust-based plan?
Yes.
So some people said yes, some people said no. So the correct answer is yes. And the reason being, so a trust, you want to have your trust properly funded. Fancy word for saying all the assets need to be either in the trust or going into the trust upon your death. So if the trust isn't properly funded and you have assets outside of the trust upon your death, now you're looking at a double administration. You have to have a probate to pour that asset into the trust, and a trust administration. So the idea is you don't want to use the will, but it should be there just in case. So one example that we see often that ends up requiring a double administration is if you purchase real property and you have a trust set up and your attorney put the property in the trust, so everything is good, and 5 years later you refinance your house. The mortgage company is going to have you take that property out of the trust. So once you do that, you think, okay, I'm good, I refinanced, but mortgage companies don't have you put it back in the trust. So if you don't remember to put it back in the trust, and upon your death, if you have more than $100,000 in equity in the real property, then it's going to require a probate. So a lot of times you're having a probate administration and a trust administration in that case. Another common question related to wills is an old will that hasn't been updated for over 10 years still effective? What do you all think?
Yes.
Yes, and that's the correct answer. Sometimes I do get calls where a client will say, my mom just passed, her will was done 20 years ago, it doesn't reflect our current family situation, so I don't think it's effective. So then you have to go through whether or not they've actually revoked the will. If you do so one way to revoke the will is actually tearing up the will. So if you tore up the original will, so there's no original copy, then at that point it would be revoked. If you've done a new will, if you're doing it with an attorney, there's usually language that says any prior wills have been revoked. But if you haven't revoked that old will, it's still effective. So I've seen a lot of situations where clients are like, well, my mom, I know she wouldn't have wanted this to happen after her death. So maybe she had disinherited a child and now they're on good terms. Well, we have to go by whatever the will said. So it's very important to look at your estate plan every couple of years and make sure it still reflects what you're wanting now, because your life will change. Okay, so another common question I get related to wills: if I am named as executor in my father's will, does this mean I have authority to sell his real property immediately after he dies? Does this mean I have authority to access his bank accounts immediately after he dies? So I see a few people shaking their heads no. So that's correct. So no. So remember how I said a will has to be probated. So it has to go through the probate court process in order to give someone legal authority under the will to administer the estate. So if they're not actually appointed by the court as your personal representative or executor, they don't have authority to access your assets. They don't have authority to list the house for sale. So that's a common misconception. I'll see people who will think that they have authority to do a lot of stuff with someone's estate after they have passed, and there's actually no legal grounds for them to be selling any property. So keep that in mind. So I'm going to touch just a little bit on trust-based versus will-based plans. So what we've been talking about is strictly will-based plans. A trust is usually set up for very specific reasons. Now, if you're setting up a trust only to avoid probate, and that's the only reason, it may not be necessary. But if you have other reasons, so these are the different things that we look at when we're helping clients set up trusts and see if it's appropriate. So if you have out-of-state property, so property in other states, especially California, you want to trust. It makes it a lot easier to manage the asset, and in certain states like California, you definitely don't ever want to have a probate. If you have a special needs beneficiary, so let's say you have a child who has autism and they're receiving special therapy through the state. If they receive an inheritance outright, they may get kicked off of those state benefits, and it could really disrupt their therapy. So it's usually a good idea to have a trust set up, basically to preserve assets, to allow for assets to be used to supplement their care, but they can also receive the benefits that they need. And sometimes the state offers certain benefits that it's very difficult to receive private pay as well. So that's something to think about. Now, tax planning. So we always joke that Arizona is a good place to die because there's no inheritance tax. Not every state is the same. There's a lot of variability. So your attorney can kind of go through that if you own property in other states as well, or if you have beneficiaries in other states. And the federal estate tax exemption. So if you're worried about that, it's a really good problem to have because it's like $13.5 million. It's adjusted for inflation. So most people don't have to worry about it. If you do, like I said, great problem to have. Blended families. So you can have trusts set up to provide for your spouse without accidentally disinheriting your child from a prior marriage. So that's really important to think about if you have a blended family. And then remarriage protection. So you can have your trust set up to where, so I'll give you an example. So I'm married and I have a child. Let's say I die and my husband gets remarried. I want to make sure some of my money goes to my daughter eventually after he passes. I want him to have ability to use it. And then after he passes, it goes to my daughter. Now I can set up the trust in a way where there's protection so that if he gets remarried, it all doesn't go to the new spouse. It'll still be preserved for my spouse's use and then my daughter. So there are ways to do that and something to think about. Also, asset protection for beneficiaries. So if you have beneficiaries who are in high-risk professions, so maybe like a neurosurgeon, a brain surgeon, there's more likelihood that they can get sued if they're business owners and they may have to file for bankruptcy, or even for just anyone who may get in a car accident and they may get sued. You can actually set up trusts so that there's beneficiary protection for the beneficiary. So you can leave your assets in a protected way upon your death. So if you're wanting to do any of those things, then a trust may be appropriate. Otherwise, with the will, that's just where everything goes outright to whomever you have listed. And this just is a quick chart to show you the differences between a trust versus a will. So you can avoid probate with both scenarios. There is more flexibility in a trust-based plan. So if you have specific conditions, so let's say you want to leave the house to allow a child to live in the house until they turn a certain age, or until they die, and then the house gets split among other beneficiaries. So those are things you would want to look at setting up trusts for. There's just a lot more flexibility with a trust versus a will. With the trust, so it doesn't require probate court to work. With the will, it does. And like I was saying before, you can provide asset protection for beneficiaries in the trust. You can in a will, but it does require probate, so it's usually not the best way to have that set up. And then incapacity planning. So a trust is set up while you're alive. So it's effective if you become incapacitated, it's going to state who you want to manage the assets for you while you're alive. And you can also do other specifications. So let's say you have a child who's dependent on you and you want them to have access to the money while you're alive. If you become incapacitated, you can specify that in a trust. Whereas a will, only effective upon death. So the next part of the presentation is on incapacity planning and ensuring your wishes are followed while you're alive. So these are important documents for everyone over the age of 18 to have. A financial general power of attorney, and we'll go over what that is and different issues we run into with those. A healthcare power of attorney, living will, and HIPAA authorization. So a durable financial power of attorney. So that is effective while you are alive and only while you are alive. So that's going to name who you want to manage your assets for you. So any assets outside of a trust. So if you don't have a trust, it'd be all of your assets while you're alive. So this is who pays your bills for you. Now, the way we practice, we do very broad powers of attorney. Ours are about 30 to 35 pages long. And sometimes clients are very shocked at that. The reason being is if you're naming someone to take care of what you need done, if you become incapacitated, you want them to have very broad powers so that they can handle anything without having to go through the court process. So we have different powers about like the ability to file taxes, apply for government benefits, collect mail on your behalf, care for your pets if you have pets. Now, it's a great responsibility and also a liability for the agent whom you name. So you want to make sure the most important thing when setting up these documents is that you have someone appointed whom you trust. So if you trust them, then you're usually okay with giving them broad powers because you want them to be able to handle your affairs if something happens to you. So they're not always accepted, and we'll go into a few issues that we run into with powers of attorney. And within the power of attorney, you can appoint a conservator. So a conservator, and I'll go into the specifics on a conservatorship, but the idea of setting up an estate plan is to try to avoid having a conservator in place or a conservatorship. But I'll get into that a little bit more. So for financial powers of attorney, one of the most common issues we see is banks won't accept them if they're too old. And one of the issues we run into is each bank has their own policy as to what is too old. So usually what we recommend is if it's older than 2 to 3 years old, you need to do an updated one and keep it updated every couple of years. Now, you can also do the bank's power of attorney form. Most banks have their own power of attorney form, and they're less likely to not accept their own form, but it's only specific to that bank account. So it doesn't include all of your other assets.
What do you mean not accept?
Meaning that they won't allow. So the question was, what does not accept mean? So that means, so let's say I'm going to use my mother's power of attorney, and I need to go to her bank and access the money to pay her bills. And I take the power of attorney into the bank, and it's more than 2 to 3 years old, the bank will say, I'm so sorry, we're not going to accept that. You can't access the assets for your mom. So that's what it means when they don't accept it. And so another common problem is if it's not broad enough. So one thing that we do at our firm is we do elder care, which is, so part of that is all text planning, Medicaid planning. So if someone's needing long-term care assistance and they don't have long-term care insurance, we work with clients to help them get approved for Arizona long-term care. So what we're looking at is preserving assets. Sometimes it's for the healthy spouse. Sometimes it's preserving the assets to supplement the care of the person who needs all text. Sometimes it's a little bit of both. But what we run into often, and we have several cases right now that are like this, is there's no specific language addressing these types of the types of transfers and gifts that we would use in this type of planning. So we're not able to do that without going through the court process and getting a conservatorship in place. So it'd be important for you to talk to your attorney about whether or not you have specific language in your power of attorney that would address these types of scenarios. And then another issue that we've run into, just to kind of give you an idea of how picky banks can be. So one of our clients was trying to access an account at a credit union on behalf of their spouse who was having some health issues. And they took the power of attorney into the credit union. And because it only said banks, not credit unions, the credit union rejected it. So it's a good idea to see if you can have a broad power of attorney. So the next point is springing versus effective immediately. So we recommend to our clients to have it effective immediately upon signing, meaning that if I have a power of attorney that I sign today, I appoint my mom or my husband, they can go today and use it at the bank if they needed to, because I trust both of them to manage my affairs if needed. Now, a lot of times we'll see other powers of attorney that'll say it's only effective if I become incapacitated. And the test for incapacity is, the determination is 2 licensed physicians. Now, sometimes it's very difficult to have a licensed physician feel comfortable with making a statement that the person has no capacity to make any financial decisions. So then there's that block where, so in my situation, if they couldn't find two physicians to make that determination for me, then my husband wouldn't be able to access those separate assets, or my mom wouldn't be able to access those assets. So it's just something to think about. Like I said, one of the most important things is to make sure it's someone whom you trust. They shouldn't be using it without your permission if you have capacity. And if they do, they can be criminally prosecuted. Okay, so what happens if you become incapacitated and you don't have a financial power of attorney, or the power of attorney is rejected by the bank? So then a conservatorship would be needed. So this is in the scenario where there's no trust involved. Then a conservatorship would be needed if you have assets over $10,000. So a conservatorship process is where you have to petition the court to get appointed. Now, there can be priority issues. So what that means is not everyone has the same level of priority to get appointed as someone's conservatorship through the court. So in our powers of attorney, we specify who you would want to have serve in that role if a conservatorship were ever needed. And if you don't have language in your power of attorney saying that, then it's spouse, then it goes to children, and there's just a whole list of priority under the statute. So with the conservatorship process, it is kind of extensive. So the court will appoint an attorney for the proposed ward, which is the incapacitated person, an investigator. So a court-appointed investigator is basically the eyes and ears of the court. They'll go and interview the different people involved to make sure a conservatorship is necessary. And a medical examiner will need to usually it's a physician or a nurse practitioner will do a report saying that the person doesn't have capacity to make their own financial decisions. A hearing is required in front of the court. Now, sometimes you can have that be telephonic, but it's still a process. You still have to have the hearing. And there's annual accounting and reporting requirements. So every year, the conservator has to do an accounting to the court as to where all the assets have gone for the year. So it's a little bit of an extensive process. So the next document is the healthcare power of attorney. So in a healthcare power of attorney, you nominate your healthcare agent. So that's who can make medical decisions for you if you're not able to make your own medical decisions. Now, a common misconception is that your healthcare agent has to be your spouse or it has to be your children, and that's not the case. If you don't trust your spouse or if you don't trust your children to make the right decisions, you can have other people listed as well. And sometimes it may not be that you don't trust them, but maybe the spouse has their own issues. Maybe they have Alzheimer's, so it'd be best to have someone else step into that role. And if you have no family or friends whom you trust, then there are professional licensed fiduciaries here in town that you can work with who will make those decisions for you. Now, within the power of attorney, you can also nominate a guardian, so you can specify who you would want to serve as a court-appointed guardian if that were ever needed. And I'll get into the scenarios of when a guardian may be needed versus the healthcare power of attorney. And you can also include funeral and disposition arrangement authority. So you can give your healthcare agent the ability to agree to an autopsy, agree to organ donations, let them know what your preference is regarding cremation or burial, and allow them to make those arrangements for you. Now in Arizona, there's also what's called a mental health power. So this allows for your agent to have the ability to have you placed in a locked psychiatric facility if needed. So this is in the scenario where if you were, so let's say you were placed in a locked psychiatric facility because you were harmed to yourself or others. So usually it's a 48 to 72 hour hold. And if they needed to have you placed longer, they have to do a petition through the court. So this would allow for your agent to be able to make that determination at that time. It's not to just lock you in a facility at any point. It has to be done with doctors and with them agreeing that you need to be placed in there. So what happens if you become incapacitated and you don't have a healthcare power of attorney? Then a guardianship is needed through the court. And it's a very similar process as what the conservatorship process is. And so a lot of times we would do joint petitions. So it'd be for guardianship, which is health and placement decisions. So health and also placement where you live. And then conservatorship is managing the assets. And a guardianship is needed if there's no healthcare power of attorney in place and there's no surrogate decision maker, or the hospital requires a guardianship. So if a lot of times if there's a dispute among family members, the hospital will want to cover themselves from a liability standpoint and require that a guardianship be appointed so that they know who they take orders from. So the guardianship makes the healthcare decisions, and that way it reduces their liability. A lot of times we'll see that when siblings don't get along, and maybe even in the scenario, if there's a healthcare power of attorney and you've listed two agents, if they don't get along, then it's likely that a guardianship will end up being needed. And so, like I was saying, it's very similar to the conservatorship process. You're still filing the petition in the court. The court's appointing an attorney for the incapacitated person. There's an investigator. There has to be a report from a physician or nurse practitioner or RN basically saying that you do not have capacity to make your own decisions. A hearing is required, and there are annual reporting requirements with the court. So some common questions related to powers of attorney. So the first is, can I access my father's bank account after his death if I am his financial power of attorney? Any answers?
No.
Correct. No, because it's only effective while you're alive. So upon death, there's no longer any legal authority under that power of attorney. And when can I make decisions for my mother as her healthcare power of attorney? Any takers? So when she no longer has the ability to make her own healthcare decisions. And that's usually a determination that the physicians are looking at when they're looking at whether or not they accept the healthcare healthcare power of attorney and the healthcare agent's decisions. Another common question I get, and this applies to a lot of people who live in Arizona for maybe half of the year. So if I have a financial power of attorney for another state, is that effective in Arizona? What do you all think?
Yes.
It depends. Great attorney question. So sometimes it can be used, but sometimes it cannot. And some of the issues we run into is with title companies. So sometimes they won't accept powers of attorney that are from other states. Banks are difficult. So sometimes they won't accept it either. So what I like to advise clients who maybe they're only here for part of the year, maybe they're only here for summer. No, probably unlikely, but when they're only here for part of the year, we want to make sure that they have a financial power of attorney that's under Arizona law, and then also a healthcare power of attorney under Arizona law. It's less likely for a hospital to not accept another state's power of attorney, but it just simplifies it because we have different laws. So like the mental health power, that's specific to Arizona. So now I can open it up to some questions. I think, Maya, you were going to ask some questions or do the online questions first.
Yeah, so thank you, Shanelle. So I do have a question about, where do I begin?
Covered a lot.
So yeah, there are so many, and I know that, when we're talking about the financial powers of attorney, that oftentimes that's always a question. People think it's just one power of attorney, but really we've got one for the financial side of things and one for the medical power of attorney. Plus,
Right.
we also have the mental health care power of attorney in Arizona. So can you have one person that is your financial power of attorney and then have a different one for your medical power of attorney? I guess that's one question that's just come up.
Right, yeah. So, yeah, and they're asking that I repeat. Okay, sure. So one of our questions is whether or not you can have a different person listed as your financial power of attorney versus your healthcare power of attorney. And yes, you can. And if a lot of times clients will say one, like in the event of their children, if they're going to list their children, one child is a lot better at financial decisions, one child is a lot better at healthcare decisions. So you want to list whomever is going to make the best decisions for you and is the best at handling financial versus health. So yes, you can.
Okay. And we also, I know we have the 5 wishes. I was going to share that so that everyone knows.
Oh, great.
5 wishes gives a little more information maybe about the kind of care that you might want.
Right.
As you're going through, the process. And so that could be helpful for folks as well. How can you avoid causing any kind of upset within the family? I know that this is such a right?
So the question is, how can you avoid causing any kind of upset within your family? So yeah, that's a great question. And I think my answer would be to make sure you have a plan laid out. Because if you think that there's going to be any kind of contention, it's going to be because there's emotions running high and your kids don't know what to do or don't know what your wishes are. So like what we offer to our clients is to have a family meeting after setting up their estate plan. That way we don't have to go over everything, but at least we can go over some of the things to try to, so that the children or whomever it is, they know what your wishes are and they hear it from you while you're alive. So I think that's the most important thing. Make sure you have these documents in place and then make sure that you share your wishes with your family, especially when it comes to healthcare. And I think some of you may not have heard Maya, but she was talking about 5 wishes and she'll be sharing that with the group. But essentially, think about what it is that you want. Everyone has different preferences when it comes to healthcare treatment. And relay that to your family. And tools like the 5 wishes or working with an attorney can help you basically lay that out for family. But 5 wishes is a great document. So
now, another question that we have is about wills. You were discussing how a will can be revoked if you've ripped up the original. What happens when, I guess, how do you know if you have the original? Have they revoked it? I guess there's always a question if there were copies floating around. How does that get determined at that point?
So it makes things more complicated. So the question is, what happens if you don't have the original will? So in Arizona, with probate court, there's two different processes. So there's what's called informal probate versus formal probate. So informal probate means that if there's a will, you have to have the original, and you have to file that with the court, and you avoid having a court hearing. So it goes basically the application and all the documents to get to open the probate will go in front of the probate county registrar, and they'll make sure that you have everything in place, and they'll appoint you without the need for a court hearing. If you don't have the original will, then it requires a hearing in front of the judge. And basically it delays things because it can be set out 30 to 60 days from when you file everything, and it can create complications. So then if you don't have the original will, there is a certain presumption that whatever copy you have may not be the actual current copy. So then you have to rebut that presumption. So it does complicate things, and it costs the state more money.
Okay. And do people, I'm just not sure, do people use any kind of video wills these days as far as maybe documenting their wishes over video?
So the question is whether or not people these days use any kind of video to document their wishes. So there is a new law that was passed not too long ago, an electronic wills law, but it's very, very complicated. I don't know any attorneys who actually practice that way because there's a lot of complications to storing that. So it's best to talk to your attorney about that. Now, so I'm just trying to think of, I would say talk to your attorney about that, but no attorney I know who's practicing uses that right now.
And I'm thinking that maybe somebody might just document, maybe not even using an attorney, but was like, these are my wishes. This is the date, that I've made these decisions. And I wasn't sure whether that would ever stand up or not.
It'd be unlikely. So the question is, if someone just documents their wishes via video and, without the help of an attorney, if that would stand up in court. And it's very unlikely because there's certain requirements for the validity of a will. So there's what's called holographic wills. So that's a handwritten will. So in they say testator. So in your handwriting, you sign and date it. So then that's a valid will. Or if it's typed up, it has to be signed and there has to be two witnesses. I believe there's a notary requirement as well. We notarize. I'd have to look at the statute again. I don't recall if it's an actual requirement, but I think it's good practice to have a notary as well. So that's how you determine if a will is valid. So I think it'd be unlikely that, I'm not sure if there are any recent cases that addresses that issue, but you're creating additional issues with your family because now they have to try to prove that was your intent through the court, and there's going to be hearings and petitions. So it's probably best to try to make sure that the will you set up is valid under Arizona law.
And Shanelle, I know oftentimes we see folks that do not have, maybe they don't have family or friends that they would want to entrust their care for, or if something was to happen to them. What is the best practice? What should they do at that point? What are the options that somebody might want to try?
Okay, yeah, that's a great question. So the question is, if you don't have any family or friends that either you don't have any that you would trust or no one's willing to serve in that capacity, there's licensed fiduciaries here in Arizona. There's also trust companies. So it depends on your situation. Most trust companies won't make any kind of medical decisions. So you're usually going to need a licensed fiduciary to step in and make healthcare decisions. What I recommend to clients in those scenarios is to meet with the licensed fiduciaries or the trust company ahead of time develop a relationship with them, make sure they know your wishes, because they're basically going to be stepping in and making decisions on your behalf. So yes, there are options, licensed fiduciaries or trust companies for financial. Licensed fiduciaries would be for medical and financial.
And are there any that, if somebody doesn't have the financial means to maybe take care of that, are there any organizations out there that are helping with that? I know there used to be. I'm not sure if there is any currently that you're aware of that would be able to help.
So the question is, if someone doesn't have financial means, so licensed fiduciaries do cost money, and trust companies as well. So if you don't have financial means, I don't know if there, like you said, Maya, there were some organizations who are handling that, and they got disbanded during the pandemic. So I know some fiduciaries do take on the case just out of the generosity of their own hearts. But it's definitely a problem that we have here in Tucson.
Okay. And if you thought that a conservatorship was something that might be necessary, how do you go about maybe discussing that or pursuing that avenue for somebody?
So the question is, if you thought that a conservatorship was necessary, how do you go about discussing that? So if a client called me and thought a conservatorship was necessary, what I'm going to go through is, what are the assets and how are they owned? If they're owned in a trust, then the trust will deal with those assets. If there are assets that are outside of the trust, then we're looking at what are those assets. So if the only asset is like Social Security income, then there's other ways to deal with that where you can become representative payee. If there are other assets that are over $10,000, then we're looking at setting up a conservatorship, and it's just going through what the situation is in terms of their family, if there's any kind of power of attorney documents in place, and at that point, then you're looking at filing the petition with the court.
Okay, great. Thank you. That is all the questions I have, Shanelle, that have come in. I want to thank you so much for being here. I'm going to turn it over to your online audience. I'm going to wrap up with our online audience. You're going to go see the in-person audience right now, and we look forward to seeing you. I know you're going to be back next month, so during Women's Health Month. So thank you again for being here today.
Thank you, Maya.
Thanks so much for being here. We look forward to, we've got several more talks coming up this month that we hope you'll join us for. The first talk that we'll have is actually not about healthcare decisions, but about stroke. And that is going to be this Friday, April 5th at 10 a.m. With Dr. David Teeple. If you are interested in that talk, please give us a call. Our phone number is 520-324-1960, and we can get you signed up for that. And then stay tuned. We've got a great talk coming up on caregiver fatigue, strategies for resilience, and that will be on Tuesday, April 16th at 10 a.m. If you're interested in attending that class, we still have space in person. The phone number, again, is 520-324-1960. Thanks so much.